Article 13. 1. Those mentioned in the preceding chapter, when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attendant. Justifying circumstances: self-defense, defense of relative, defense of stranger, unlawful aggression must be present for Art. 13 to be applicable. Other two elements not necessary. If two requisites are present, considered a privileged mitigating circumstance. Example: Juan makes fun of Pedro. Pedro gets pissed off, gets a knife and tries to stab Juan. Juan grabs his own knife and kills Pedro. Incomplete self-defense because although there was unlawful aggression and reasonable means to repel was taken, there was sufficient provocation on the part of Juan. But since two elements are present, it considered as privileged mitigating. B. State of necessity, par 4, avoidance of greater evil or injury. If any of the last two requisites is absent, there's only an ordinary mitigating circumstance. Example: while driving his car, Juan sees Pedro carelessly crossing the street. Juan swerves to avoid him, thus hitting a motorbike with two passengers, killing them instantly. Not all requisites to justify act were present because harm done to avoid injury is greater. Considered as mitigating. C. Performance of duty, par 5. Example: Juan is supposed to arrest Pedro. He thus goes to Pedro's hideout. Juan sees a man asleep. Thinking it was Pedro, Juan shot him. Juan may have acted in the performance of his duty, but the crime was not a necessary consequence thereof. Considered as mitigating. Exempting circumstance: A. Minority over 9 and under 15. If minor acted with discernment, considered mitigating. Example: 13-year-old stole goods at nighttime. Acted with discernment as shown by the manner in which the act was committed. B. Causing injury by mere accident. If second requisite, due care, and first part of fourth requisite, without fault, thus negligence only, are absent, considered as mitigating because the penalty is lower than that provided for intentional felony. Example: police officer tries to stop a fight between Juan and Pedro by firing his gun in the air. Bullet ricocheted and killed Petra. Officer willfully discharged his gun but was unmindful of the fact that area was populated. C. Uncontrollable fear. Only one requisite present, considered mitigating. Example: under threat that their farm will be burned, Pedro and Juan took turns guarding it at night. Pedro fired in the air when a person in the shadows refused to reveal his identity. Juan was awakened and shot the unidentified person. Turned out to be a neighbor looking for his pet. Juan may have acted under the influence of fear, but such fear was not entirely uncontrollable. Considered mitigating. 2. That the offender is under 18 years of age or over 70 years. In the case of a minor, he shall be proceeded against in accordance with the provisions of Art. 192 of PD 903. Applicable to A. Offender over 9, under 15 who acted with discernment. B. Offender over 15, under 18. C. Offender over 70 years. Age of accused, which should be determined as his age at the date of commission of crime, not date of trial. Various ages and their legal effects. A. Under 9 exemptive circumstance. B. Over 9, below 15 exemptive, except if acted with discernment. C. Minor delinquent under 18 sentence may be suspended, PD 603. D. Under 18 privileged mitigating circumstance. E. 18 and above, full criminal responsibility. F. 70 and above, mitigating circumstance, no imposition of death penalty. Execution. G. Of death sentence if already imposed is suspended and commuted. 3. That the offender had no intention to commit so grave a wrong as that committed, prater intentionam. Can be used only when the facts prove to show that there is a notable and evident disproportion between means employed to execute the criminal act and its consequences. Intention, as an internal act, is judged by the proportion of the means employed to the evil produced by the act, and also by the fact that the blow was or was not aimed at a vital part of the body. Judge by considering 1. The weapon used, 2. The injury inflicted, and 3. The attitude of mind when the accuser attacked the other. Example: Pedro stabbed Tomas on the arm. Tomas did not have the wound treated, so he died from loss of blood, Not applicable when offender employed brute force. Example, rapist choked victim. Brute force of choking contradicts claim that he had no intention to kill the girl. Art. 13. Par 3 addresses itself to the intention of the offender at the particular moment when he executes or commits the criminal act, not to his intention during the planning stage. In crimes against persons, if victim does not die, the absence of the intent to kill reduces the felony to mere physical injuries. It is not considered as mitigating. Mitigating only when the victim dies. Example, as part of fun making, Juan merely intended to burn Pedro's clothes. Pedro received minor burns. Juan is charged with physical injuries. Had Pedro died, Juan would be entitled to the mitigating circumstance. Not applicable to felonies by negligence. Why? In felonies through negligence, the offender acts without intent. The intent in intentional felonies is replaced by negligence, imprudence, lack of foresight or lack of skill in culpable felonies. There is no intent on the part of the offender, which may be considered as diminished. Basis of Par 3. Intent, an element of voluntariness in intentional felony, is diminished for that the sufficient provocation or threat on the part of the offended party immediately preceded the act. Provocation, any unjust or improper conduct or act of the offended party, capable of exciting, inciting or irritating anyone. Basis. Diminution of intelligence and intent requisites. A. Provocation must be sufficient. 1. Sufficient, adequate enough to excite a person to commit the wrong and must accordingly be proportionate to its gravity. 2. Sufficiency depends on the act constituting the provocation, the social standing of the person provoked, time and place provocation took place. 3. Example, Juan likes to hit and curse his servant. His servant thus killed him. There's mitigating circumstance because of sufficient provocation. 4. When it was the defendant who sought the deceased, the challenge to fight by the deceased is not sufficient provocation. B. It must originate from the offended party. 1. Why? Law says the provocation is on the part of the offended party. 2. Example, Tomas' mother insulted Petra. Petra kills Tomas because of the insults. No mitigating circumstance because it was the mother who insulted her, not Tomas. 3. Provocation by the deceased in the first stage of the fight is not mitigating circumstance when the accused killed him after he had fled because the deceased from the moment he fled did not give any provocation for the accused to pursue and attack him. C. Provocation must be immediate to the act, i.e., to the commission of the crime by the person who is provoked. Why? If there was an interval of time, the conduct of the offended party could not have excited the accused to the commission of the crime, he having had time to regain his reason and to exercise self-control. Threat should not be offensive and positively strong because if it was, the threat to inflict real injury is an unlawful aggression which may give rise to self-defense and thus no longer a mitigating circumstance. 5. That the act was committed in the immediate vindication of a grave offense to the one committing the felony, delito, his spouse, ascendants, descendants, legitimate, natural or adopted brother or sisters, or relatives by affinity within the same degree. 1. Requisites. There's a grave offense done to the one committing the felony etc. that the felony is committed in vindication of such grave offense. 2. Lapse of time is allowed between the vindication and the one doing the offense, proximate time, not just immediately after. 3. Example, Juan caught his wife and his friend in a compromising situation. Juan kills his friend the next day, still considered proximate. Provocation. Vindication. Made directly only to the person committing the felony grave offense may be also against the offender's relatives mentioned by law. Cause that brought about the provocation need not be a grave offense. Offended party must have done a grave offense to the offender or his relatives necessary that provocation or threat immediately preceded the act. No time interval may be proximate. Time interval allowed more lenient in vindication because offense concerns the honor of the person. Such is more worthy of consideration than mere spite against the one giving the provocation or threat. Vindication of a grave offense and passion and obfuscation can't be counted separately and independently. 6. That of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. Passion and obfuscation as mitigating. When there are causes naturally producing in a person powerful excitement, he loses his reason and self-control, thereby dismissing the exercise of his willpower. Passion and obfuscation are mitigating circumstances only when the same arise from lawful sentiments, not mitigating circumstance when done in the spirit of revenge or lawlessness. Requisites for passion and obfuscation: A. The offender acted on impulse powerful enough to produce passion or obfuscation. B. That the act was committed not in the spirit of lawlessness or revenge. C. The act must come from lawful sentiments. Act which gave rise to passion and obfuscation: A. That there be an act, both unlawful and unjust. B. The act be sufficient to produce a condition of mind. C. That the act was proximate to the criminal act. D. The victim must be the one who caused the passion or obfuscation. Example: Juan saw Tomas hitting his son. Juan stabbed Tomas. Juan is entitled to mitigating circumstance of P&O as his actuation arose from a natural instinct that impels a father to rush to the rescue of his son. The exercise of a right or a fulfillment of a duty is not the proper source of P&O. Example: A policeman arrested Juan as he was making a public disturbance on the streets. Juan's anger and indignation resulting from the arrest can't be considered passionate obfuscation because the policeman was doing a lawful act. The act must be sufficient to produce a condition of mind. If the cause of the loss of self-control was trivial and slight, the obfuscation is not mitigating. Example: Juan's boss punched him for not going to work the other day. Cause is slight. There could have been no mitigating circumstance of P&O when more than 24 hours elapsed between the alleged insult and the commission of the felony, or several hours have passed between the cause of the P&O and the commission of the crime, or at least half an hour intervened between the previous fight and subsequent killing of deceased by accused. Not mitigating if relationship is illegitimate. The passion or obfuscation will be considered even if it is based only on the honest belief of the offender, even if facts turn out to prove that his beliefs were wrong. Passion and obfuscation cannot coexist with treachery since the means that the offender has had time to ponder his course of action. Passion and obfuscation arising from one and the same cause should be treated as only one mitigating circumstance. Vindication of grave offense can't coexist with passion and obfuscation. Passion and obfuscation irrespective force mitigating exempting no physical force needed requires physical force from the offender himself must come from a third person must come from lawful sentiments. Unlawful passion and obfuscation provocation produced by an impulse which may be caused by provocation comes from injured party offense, which engenders perturbation of mind, need not be immediate. It is only required that the influence thereof lasts until the crime is committed. Must immediately precede the commission of the crime. Effect is loss of reason and self-control on the part of the offender. Same 7. That the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. 2 mitigating circumstances present. A. Voluntarily surrendered. B. Voluntarily confessed his guilt. If both are present, considered as 2 independent mitigating circumstances. Mitigate penalty to a greater extent. Requisites of voluntary surrender. A. Offender not actually arrested. B. Offender surrendered to a person in authority or the latter's agent. C. Surrender was voluntary. Surrender must be spontaneous. Shows his interest to surrender unconditionally to the authorities. Spontaneous emphasizes the idea of inner impulse, acting without external stimulus. The conduct of the accused, not his intention alone, after the commission of the offense, determines the spontaneity of the surrender. Example: surrendered after 5 years, not spontaneous anymore. Example: surrendered after talking to town councilor. Not vs because there's an external stimulus. Conduct must indicate a desire to own the responsibility. Not mitigating when warrant already served. Surrender may be considered mitigating if warrant not served or returned unserved because accused can't be located. Surrender of person required. Not just of weapon. Person in authority, one directly vested with jurisdiction, whether as an individual or as a member of some court, government, corporation, board, commission. Barrio captain, chairman included. Agent of person in authority, person who by direct provision of law, or b. election, or by appointment by competent authority is charged with the maintenance of public order and the protection and security of life and property, and any person who comes to the aid of persons in authority. RPC does not make distinction among the various moments when surrender may occur. Surrender must be by reason of the commission of the crime for which defendant is charged. Requisites for plea of guilty: a. Offender spontaneously confessed his guilt. b. Confession of guilt was made in open court, competent court. c. Confession of guilt was made prior to the presentation of evidence for the prosecution. Plea made after arraignment and after trial has begun does not entitle accused to have plea considered as mitigating circumstance. Plea in the RTC in a case appealed from the MTC is not mitigating. Must make plea at the first opportunity. Plea during the preliminary investigation is no plea at all. Even if during arraignment, accused pleaded not guilty, he is entitled to mitigating circumstance as long as withdraws his plea of not guilty to the charge before the fiscal could present his evidence. Plea to a lesser charge is not mitigating circumstance because to be voluntary plea of guilty must be to the offense charged. Plea to the offense charged in the amended info, lesser than that charged in the original info, is mitigating circumstance. Present rules of court require that even if accused pleaded guilty to a capital offense, it's mandatory for court to require the prosecution to prove the guilt of the accused, being likewise entitled to present evidence to prove, inter alia, mitigating circumstance 8. That the offender is deaf and dumb, blind or otherwise suffering from some physical defect with c. thus restricts his means of action, defense or communication with his fellow beings. Basis: one suffering from physical defect which restricts him does not have complete freedom of action, and therefore, there is diminution of that element of voluntariness. No distinction between educated and uneducated deaf, mute or blind persons. The physical defect of the offender should restrict his means of action, defense or communication with fellow beings. This has been extended to cover cripples, armless people, even stutterers. The circumstance assumes that with their physical defect, the offenders do not have a complete freedom of action, therefore diminishing the element of voluntariness in the commission of a crime. 9. Such illness of the offender as would diminish the exercise of the willpower of the offender with o. depriving him of consciousness of his acts. Basis: diminution of intelligence and intent. Requisites: a. Illness of the offender must diminish the exercise of his willpower. b. Such illness should not deprive the offender of consciousness of his acts. When the offender completely lost the exercise of willpower, it may be an exempting circumstance. Deceased mind, not amounting to insanity, may give place to mitigation 10. And any other circumstance of a similar nature and analogous to those above mentioned. Examples of any other circumstance: a. Defendant who is 60 years old with failing eyesight is similar to a case of one over 70 years old. b. Outraged feeling of owner of animal taken for ransom is analogous to vindication of grave offense. c. Impulse of jealous feeling, similar to passion and obfuscation. d. Voluntary restitution of property, similar to voluntary surrender. e. Extreme poverty, similar to incomplete justification based on state of necessity. Not analogous: a. Killing wrong person. b. Not resisting arrest, not the same as voluntary surrender. c. Running amok is not mitigating. Mitigating circumstance which arise from a. Moral attributes of the offender. Example: Juan and Tomas killed Pedro. Juan acted with passion and obfuscation. Only Juan will be entitled to mitigating circumstance. b. Private relations with the offended party. Example: Juan stole his brother's watch. Juan sold it to Pedro, who knew it was stolen. The circumstance of relation arose from private relation of Juan and the brother. Does not mitigate Pedro. c. Other personal cause. Example: Minor, acting with discernment, robbed Juan. Pedro, passing by, helped the minor. Circumstance of minority, mitigates liability of minor only. Shall serve to mitigate the liability of the principals, accomplices and accessories to whom the circumstances are attendant. Circumstances which are neither exempting nor mitigating: a. Mistake in the blow. b. Mistake in the identity of the victim. c. Entrapment of the accused. d. Accused is over 18 years old. e. Performance of a righteous action. Example: Juan saved the lives of 99 people but caused the death of the last person, he is still criminally liable. Aggravating circumstances. Definition: those circumstances which raise the penalty for a crime without exceeding the maximum applicable to that crime. Basis: the greater perversity of the offense as shown by a. the motivating power behind the act, b. the place where the act was committed, c. the means and ways used, d. the time, e. the personal circumstance of the offender, f. the personal circumstance of the victim. Kinds: a. generic, generally applicable to all crimes. b. specific, apply only to specific crimes, ignominy, for chastity crimes, treachery, for persons crimes. c. qualifying, those that change the nature of the crime, evident premeditation, becomes murder. d. inherent, necessarily accompanies the commission of the crime, evident premeditation in theft, estafa. Qualifying aggravating circumstance. Generic aggravating circumstance. Gives the proper and exclusive name, places the author thereof in such a situation as to deserve no other penalty than that specifically prescribed by law. Increase penalty to the maximum, without exceeding limit prescribed by law. Can't be offset by mitigating circumstance. May be compensated by mitigating circumstance. Must be alleged in the information. Integral part of the offense need not be alleged. May be proved over the objection of the defense. Qualifying if not alleged will make it generic aggravating circumstances which do not have the effect of increasing the penalty. 1. Which themselves constitute a crime specifically punishable by law or which are included in the law defining a crime and prescribing the penalty thereof. Example: breaking a window to get inside the house and rob it. 2. Aggravating circumstance inherent in the crime to such degree that it must of necessity accompany the commission thereof. Example: evident premeditation inherent in theft, robbery, estafa, adultery and concubinage. Aggravating circumstances are not presumed. Must be proved as fully as the crime itself in order to increase the penalty.